Welcome to this month's Minute with Victor, where Dr. Cotton answers your questions.
This month's question comes from a physician who writes, I like your common sense approach, but I'm skeptical because our legal system is so dysfunctional. Take the McDonald's hot coffee lawsuit. A woman said she didn't know coffee was hot and burned herself, blamed it on McDonald's, and the jury gave her $3 million. I read about malpractice cases that are just as ridiculous. Can you reconcile these outcomes? Well, I'll give it a try. The Sixth Amendment gives us the right to a fair trial, but it doesn't say anything about a perfect trial. So we can begin by saying that our legal system wasn't designed to be perfect, it's not perfect, and it occasionally produces results that are not what we expect. But is that really any different than the practice of medicine? Suppose a patient has an infection. You correctly prescribe an antibiotic, but the patient suffers an unpredictable reaction and dies. Now, how do we reconcile that? By recognizing that it's an exception. It does happen, but antibiotics are still valuable and we still rely upon them. Now, I want you to apply that thinking to these unusual malpractice cases and recognize that they're probably the exception, which is why they're newsworthy. Remember, despite what you read, physicians still win most malpractice lawsuits. It's also important to recognize that many of these cases aren't reported accurately. According to the court documents, Stella Liebeck, who was 79 years old, ordered coffee at McDonald's. Although the industry standard was to serve coffee at 155 degrees, this coffee was 190 degrees. As Liebeck removed the lid, the entire contents spilled into her lap, causing third-degree burns over her thighs, groin, and perineum. She subsequently spent 8 days in the hospital and underwent 5 surgical procedures that included skin grafting. At trial, McDonald's admitted that it intentionally superheated coffee to enhance flavor, but did not warn its customers. McDonald's also admitted that more than 700 patrons had suffered serious burns, many of them third-degree burns, but the company did not change its practices. The testimony infuriated the judge, who called the behavior callous, reckless, and willful. The jury awarded $2.9 million. Somebody's always talking about some lawsuit from somewhere, but what they're saying may not be correct. And even when it is, it's probably the exception, not the rule. Thanks again for listening. We've added a new feature to our website that I think you'll enjoy. It's an audio series where I discuss scientific papers that are foundational to our understanding of medical malpractice. I undertook this project because most of the risk management ideas, the things that we're told will reduce our risk of being sued, are in fact inconsistent with the literature. I sort those ideas out by putting each of them to the test in this new series called The Crucible. It's available here on our website at no cost, and I hope you find it helpful.